Any mention?
May it please your lordships. Lordships, I beg to make a mention of item 4 and 5, lordships. Please connect 4 and 5.
4 and 5. Mr. Paul is not there.
No, lordships.
So what to do?
Lordships, I pray if this matter may come up after 2 weeks.
Other side, where's other side? Dr. Musga is not
Lordships, they are appearing on the other side.
Oh, Agarwal. You have no objection?
Lordship, I am in item number 4. No.
Yeah, objection or not?
No, Lordship.
Yes, after 2 weeks, yes. 5 also.
Lordships. Lordships, interim you can continue,
No
lordships.
interim or continuous.
Highly obliged, lordships.
Obliged, Lordships.
Yes.
Item number 1.
May I please, Your Worship, this is with regard to the GST tax, Your Worship. Here, Your Worship, the petitioner is having a form, Your Worship, in William Nagar, and accordingly, GST registration was issued to him, Your Worship, on which is in Annex 1. Then thereafter, Your Worship, the petitioner failed to file a return file, Your Worship, for 6 months, that is from December 2023 to May 2024, Your Worship. And accordingly, the respondent had filed a show cause notice to the petitioner for cancellation of
What's the show cause notice?
which Annex 2, Your Worship, page 13.
Then what happened after that?
Then after that, Your Worship, the petitioner failed to file a show cause within the stipulated time, Your Worship. So accordingly, the registration was cancelled, Your Worship. And thereafter, Your Worship, the petitioner had filed a pending return file, Your Worship, but till date they have not restored or cancelled the.
No, but then you filed it after the.
Yes, Your Worship. Being aggrieved by that only, we are.
Why you come? Yes.
May it please your lordship, sir, the petitioner has been sleeping on his rights. He had many alternatives to file a reply, or in the alternative to actually submit his returns and pay the tax, in which case the matter would have come to a conclusion. And lordship, there's an appellate process under 107 of the Act.
Yes. You take instruction from your client.
Yes.
Right, Mr. D. Nuta, the counsel petitioner. No notice at this stage, and Mr. Atias SD's present behalf of all the respondents.
Behalf of the respondents.
Preliminary objections have been raised as to the availability of alternate remedy. Mr. D. Nuta to obtain instructions. Yes, as to whether he wants to pursue this matter before this court. Just after 2 weeks, yes.
All right.
Yes.
Item number 2.
May I please, Lordship. My Lord, in item number 2, my Lord, we are filing an additional affidavit today, Lordship. So in fact, my Lord, it was ready, my Lord. Yesterday, some defects were pointed out, so we are.
Where's your local council? With local council? Where's your local council? Yes?
For petitioner, my Lord, Miss Purnima Rai is appearing, my Lord.
No. Where's your local council, Mr. Chitia?
My Lord,
if you say your affidavit is going to be filed in the course of the day, there should be someone here.
yes, during the course of the file, my Lord.
During the?
In fact, my Lord.
During the course of the day, filing it.
Lordship. My Lord, in fact, my Lord, yesterday we also, my Lord, tried to file, my Lord, some defects were pointed on, my Lord. I am told by, my Lord.
Right, okay, Mr. S. Chitia submits the additional affidavit. Will be filed in the course of the day, just after 2 weeks of further orders, yes.
My Lord, may I submit your Lordship? So far as their affidavit, my Lord, they have served what's copy. We are not going to file any reply, my Lord. So let the matter be taken up for hearing, my Lord, next date. In fact, it was earlier heard also.
Yes, Mr. A. Goyal appearing for the respondent number.
For the petitioner, my Lord.
For the petitioner or submits that they've already been served a copy and no rejoinder be necessary. So accordingly, it's a matter for hearing after 3 weeks. Yes.
Deeply obliged.
Obliged.
Item number 3.
May it please your lordships, I'm praying for some time to file an affidavit
How much time you prayed for the first
This is
time?
the first time, Lordship.
Yes, how much time?
3 weeks.
Yes, MS American by Dr. Praise for about 3 weeks time to file affidavit. Yes,
But interim order may be
interim order we need to continue. What's the matter about?
is a challenge
Challenging the
demand notice and the show cause. No?
GST adjudication order as well as the show cause.
okay. Yes.
Obligation.
Any mention?
May it please your Lordship.
Yes.
Lordship, I'm mentioning one matter for urgent listing for tomorrow, Lordship. This matter pertains to the Shidakandi VEC election, Lordship, at Batabari Block West Garo
What's
Hills.
the urgency in VEC?
Lordship, what happened is
Is
that
it pending
in this
matter?
No, Lordship, it's a fresh matter. What happened
Okay,
in this
yes.
matter?
Yes.
Lordship.
Yes. Yes.
Lordship, I beg to mention item number. Lordship, I beg to mention item number 34, Lordship, hearing, Lordship. I was supposed to come to Shillong for the hearing, Lordship, but due to this prevailing situation, I had to come back midway, Lordship.
Why?
I couldn't go, Lordship.
Okay.
Lordship, the taxis were blocked at Khanapara, Lordship. I was not allowed to go to Shillong, Lordship.
Yes, okay. After 1 week?
After 1 week.
Lordship, may I pray the 3rd of September, Lordship.
3rd September is not a good date. Yes.
3rd of September, Lordship.
No, that's not a good date, Mr. Charwati.
4th of September, Lordship.
First week I'll be out of station,
What's the
madam.
holiday?
First week we will be out of station, madam. After 1 week, madam. Or after 10, madam. 10 or 11.
We'll have it on 9 September.
Yes.
Lordship, 9. My senior, Mr. P.K. Rochan, is difficult 9, 10, and 11, Lordship. The 4th will be very convenient for him, Lordship.
4th holiday here, Mr. Charwati, please have to understand. The court is closed.
Okay, Lordship. Okay.
9th, yes.
Okay, Lordship. Lordship.
May it please your Lordship. Lordship, I beg to make a mention of item number 18, Lordship.
$18?
18, Lordship.
He's my wife, Dr. Mozika. What is 18, 19, 20?
Lordship, we were supposed to file an affidavit. We have filed our additional affidavit, Lordship.
21. You already filed it?
Lordship.
When?
31st, Lordship.
The file an affidavit.
Yes?
The file affidavit.
What does it say?
There's nothing better than that.
So when? 18 to 21?
Lordship.
Okay, after 2 weeks, yes. Others will, next date will close them. Yes.
Yes, please.
Highly obliged, Lordship.
Yes.
My Lord, I beg to mention number 28. Item number 28. Mr. Philip Nombri is on sanction leave, my Lord.
No sanction leave, he's on leave. Sanction leave is, yes. Who's the other side? No objection? Okay, yes. Yes.
Much obliged.
Please, Your Lordship, I beg to mention item number 29.
On behalf of?
On behalf of AG Moon.
No objection, madam.
After 2 weeks.
No urgency? You're the petitioner.
Yes.
No urgency? Yes or no?
No. Not
Why is it
urgency.
small voice, what happened?
No,
Lost your voice somewhere?
no. No
Okay,
objection, madam.
Usually you're very vocal, how come it's keeping quiet? Yes.
After 2
Yes.
weeks.
That's what I was
Yes.
Lordship, item number 32, Your Lordship. Can the matter come after 2 weeks, Your Lordship? I need 2 weeks time to prepare.
2 weeks time to prepare as an absurd proposition. Yes.
No objection, Your Lordship.
2 weeks. Yes. You can write a book in 2 weeks. Yes.
Right, Your Lordship.
Please, Your Lordship, I beg to mention item number 23. The conducting counsel is having some personal difficulties, Your
Who's the
Lordship.
counsel?
My Lord, Your Lordship, we were supposed to produce some original
Who's the
documents.
counsel?
The learned AEG in July, Lordship.
Mr.
He's not
Shulai.
here today.
Mr. Shulai, my Lord.
He's having
not
some
here today.
personal difficulties. He's here, Your Lordship, but he's having some personal.
23 to 26, my Lord, they were supposed to file an affidavit
Regarding?
to bring on record the
Original records, Your Lordship.
yes.
We'll
the-
place it next week, Your Lordship.
I got
Maybe for 1 week's time.
1 second.
the proceeding of the
You're supposed to bring the same record by way of affidavit, not producing the records.
Yes.
Stop. Today, by order dated 5/8/2026, the state respondents were allowed to bring the instructions on record with affidavit. Today, some more time is sought by the learned GA. Stop. In interest of justice, it's up to 1 week. File it. After it be filed before the next date. Yes.
Up to 26 is connected, my lord. 23, 24, 25, 26.
Okay, yes.
My lord, much obliged.
So tell your senior, this has to be filed.
Yes, sir.
Supplementary list. Item number 1.
May I please, Lordship? Lordship, this is contempt petition, Lordship. Operative part is at page number 10, Lordship. Paragraph 7.
Yes. They have not done that. 3
Yes,
months
Lordship,
is elapsed.
Lordship.
When does the order pass? March. Okay, heard Mr. M.R. Marak. The company issue notice. Returnable in 3 weeks. Steps to be taken within 3 days. Yes.
Much obliged, Lordship.
Daily list. Item number 1.
Lordship, we were supposed to file an impediment here, Lordship. We'll be filing it in the course of the day.
Yes. Yes, Mr. Mar, what's the matter?
Lordship, you're supposed to file the depletement and the last date 7/7.
Yes, why you not filed it?
We just obtained the address.
The course of the day.
Yes.
You're Mr.
TCS Lama.
Yes, Mr. T. Slama, the petitioner submits that the application for impediment will be filed in the course of the day, just after 1 week.
Lordship.
2.
Yes,
This is arbitration, appointment arbitration.
yes. What's it for today?
Well, this is a matter that they agreed for appointment to Justice Wi-Fi, my lord.
They've agreed.
At that point of time, my lord, earlier. Then
Mr. Alam, you're not audible. Unmute yourself. Mr. Alam, correct?
Alam.
What's his name?
Yes, my lord. Alam.
Yes. Unmute yourself. What are you doing?
Doing from here.
What are you doing? We can't hear you. Yes, sir.
We can't hear you.
Can't hear you. Who's local counsel?
There's no one.
Cannot hear you. Unmute yourself. He can't hear us, I think. It's becoming absurd, yes.
After 2 weeks, my lord.
Yes, Mr. Alam, counsel for the petitioner, we'll have it next week. It's inaudible. List after 1 week. Yes.
3.
Can't hear you. Overload, I think doesn't know how to manage the virtual hearing.
May I please, Lordship? My lord,
Yes, what instruction have you received?
my lord, 6th July. 6th July order is
Yes. 13.114%.
Definitely, my lord.
Then
Thereafter, what?
this is 6 July. Yes.
Attributability could not be decided, my lord. Because this was medical assessment done after 40 years, my lord.
There's some decision, correct? But even after 40 years also, there's some of which not Himachal High Court, another one.
Yes, my lord. Relying on that, the order was passed in this
Himachal High Court,
my lord, saying that you can conduct a fresh medical examination, my lord.
So 13.1.
That also not attributable to service, my lord.
No, 13.114%. Will it be permanent disability? As
Yes.
percentage.
But attributability,
No,
my
not
lord.
the attributable service. The thing is that whether he's disabled, correct? 13.114. What is the permanent disability percentage for?
My lord, but there is a four layer, my lord.
Yes.
1 to 49 is count as a 50. That's a minimum
1 to
1% till the 50%, my lord. That is in one category. That is the minimum pension is to be given, my lord. And thereafter, the second is after 50 to 70%, second category, my lord. And
higher pension.
My lord. And third is the 100%, my lord.
That show?
My lord, my lord, I have to file an affidavit by you, my lord. Yeah, it is a contempt.
Show that formula. Attributability now, and the US we read against the judgment. So you discharged from service when?
1976, my lord.
And what is the nature of disability?
My lord, the nature of disability was hypertension as well as the elbow entire fracture, my lord. Because of the hypertension, he fell during the service, my lord.
But then they have no documents, no materials to
My
show
lord,
that it was done during the service.
My lord.
In 1976, when you discharged, how old were you?
That time, my lord.
Right now is, my lord.
Right now, 77 years, my lord.
77 years old. So 76 years old. 76, that means 26 plus
50 years,
26, 52 years ago. Yeah, that means he was 25.
25, 26.
My lord, we are in the contempt proceeding, my lord. It is the compliance which is
No, but the compliance is awaited because now the thing is that you bring a formula, yes.
My lord,
Today, the learned DGSI, Dr. M. Mozikal, I has produced a medical report showing the percentage of disability assessed is at 13.114%. Stop, Mr. Arja, please get out to take instructions and to come with materials to show that the petitioner would be eligible
entitled for the pension.
grant of disability pension.
Mal.
Yes. List after
1 week, mal.
1 week, yes.
4.
Your Lordship, respondent number 1 to 4 is supposed to place their objection.
Please, Your Lordship, I'll require another 2 weeks' time to file my affidavit, Your Lordship.
Who is appearing for the respondent number 5?
Respondent number 5, we are not filing, Your Lord.
Any interim order?
We have
no.
No, Lordship.
Yes, MS, please. How many times you've taken? When is the matter filed?
2025,
Lordship, yes. There's interim order, yes. There's interim.
But it was never renewed.
There's an interim order for appeal letter dated.
What's the matter about?
This is a matter about that Sadar of Lumpulon Mokenreo. So there's a practice that the Mukim clan they used to say.
Oh yes. Okay. MSP is now be praised funds allowed further to extend file affidavit stop. MSMD Shilan we have notified submit the note after report coming from the respondent. Stop. list after 2 weeks. Interim order, if any.
Highly obliged.
Much obliged, my lord.
5.
Please, Lordship.
My lord, I received an instruction that they are willing to part that 10 bika to the
I have no instructions,
respondent
Lordship, on that, Lordship.
as directed by the order of this subordinate court.
By the order of the
subordinate court.
Where is that?
It is page 64, my lord.
Why are it receiving instruction, Mr.
Instruction, it is
No,
barbar
I'm telling, where is that?
With regards to the settlement, Your Lordship, I've been informed there's no settlement, Your Lordship.
So you said they're willing to give you 10 bigas?
Yeah, ready to 10 bika. The court also gave 10 bika.
Where is that? Where is that part?
I read 64 page that from that thing.
Paragraph?
4. From paragraph 5. Not paragraph 5 as this stanza sentence 5, my lord.
From paragraph 5?
Yeah, para 5. This 64. I will read, my lord.
Yes.
He is of the contention that the plot of land measuring 10 bika did not belong to the appellant, as said the land was gifted to the respondent by the Nokma of Dagulgre Akeng.
Who contended this? Who contended this? You?
Yeah. So I received an instruction, they are willing to give 10 bika.
I'll just take specific instructions, Lordship, on this.
Why not taking some last time also?
With regards
Forgot
to this,
about the case.
No, with regards to the settlement, Your Lordship, that's my
Yes,
instruction.
though Mr. Parsanti maintains that there are no talk settlement, Mr. L.M. Sangma today has submitted that the writ petitioner is willing to part with 10 bigas of land in favor of the respondent, which is in accordance with the order of the district sessions judge, dated 27/5/2025.
Yeah.
Learned counsel has also taken this court to that portion which is contained in paragraph 5 of the order. So, according to this matter, after 2 weeks, Mr. Parsanti the positivity of the instructions. Is Mr. Paske's case?
No, Your Lordship.
Then you obtain instructions otherwise.
Highly
You're in contact with the client.
My senior is, Your Lordship.
Appears so. Yes. Yes.
Lordship, the main Lordship, this matter may come up after a week's time. The main matter is coming up on at this coming Tuesday, Lordship.
For filing of written arguments, my lord.
After 2 weeks.
Highly obliged, Lordship.
7.
Wait, please, Your Lordship. In this case, Your Lordship, we have already complied with the Honourable Court's order by paying the DCRG to the petitioner.
Yes.
And there is nothing pending. No payment is pending.
No, my lord. To my understanding, if my lord may kindly come to the order which was passed by the Honourable Court, my lord.
You know the order?
Order, my lord.
Order
Page
is
15.
page 14,
Let me complete
15.
this. Para 2 of this page 15, my lord.
Yes.
Challenge the resignation during his lifetime, and it was only in the year 2021 that his letter of resignation was being questioned by his wife. We cannot overlook the fact that the prima facie the writ petitioner could not be entitled to gratuity.
Could be entitled.
Yeah, could be entitled to gratuity. Even according to the respondent, the deceased husband of the writ petitioner has rendered 17 years of continuous service, and in view of Section 4 of Payment of Gratuity Act 1972, he will be otherwise entitled to the payment of gratuity on his resignation. Gratuity has not been paid, and for what reason they are not paying, my lord? They have not specified anything in the.
Now they said to comply with the order.
Death cum retirement gratuity has already been paid. Now, what does my friend mean by gratuity?
Where is the-
Gratuity is a broader term for a DCRG,
Yes.
which is a specific term for government employees.
Please let me complete.
No, I am assisting the court.
Yes, my lord. See, my lord, may kindly come to the affidavit. My lord, may come to page 7 of the affidavit that they have filed, my lord.
See, contempt, Mr. Day.
My lord, whether the order has been complied.
See, not the question is whether. It's whether there is any willful violation.
My lord.
If there's attempts also made, that means there's no willful violation. If there's a affront to the order of the court, then contempt will be drawn.
My lord, exactly.
Otherwise you.
Yes, my lord.
If
Page
you are-
7
if
of
you
the
are
affidavit.
happy with the
only.
manner of implementation, you. Where is that?
My lord, may kindly see serial number 3, my lord. Recoveries, provisional gratuities, 0. to the recoverer. Now, my lord,
Where are you
reading
from?
Page 7 of their affidavit, my lord.
Yes. Yes.
Now, 17 years of my service, my lord, gratuity which they are saying, my lord, that they have paid is 11,725 rupees.
Yes.
My lord, may what is my lord, serial number 3? My lord?
See, you're not going to see what the order says. You'll not be eligible for pension or DCRG as per court order.
But as per the court order, my lord.
Yes.
Exactly, my lord. Now, this court order has not been under challenge, my lord. Whether code was correct or wrong, my lord.
No, forget about the DC. As per the court order, you're trying to DCRG and they paid you. That comes retirement gratuity. So, things otherwise we dispose.
My lord, may kindly see the order of the
Has been complied with.
order of the High Court, my lord.
You file a fresh petition.
Let me take instruction, my lord. Let it come after 2 weeks, my lord. I'll take instruction from the client.
Yes, the prayer. Just after 2 weeks. He resigned in 24 or somewhere. Yes.
94, your lordship, he
94,
resigned,
yes,
and
exactly.
they never.
How much money will come? That will be 11,000.
And during his lifetime, they never
Anyway,
came forward.
17 years of my
It was
service,
only
my
his
lord.
wife who has come after his death.
What else?
You answer.
Yes, MS Kohli.
My lord, it's the accountant general who has to answer, madam.
Your lordship, I had just received the copies yesterday, your lordship.
When you received?
Yesterday, your lordship.
5/8 was the order for supply of copies.
Lordship.
You keep yesterday only.
Inadvertently, yes, lordship.
Inadvertently, then we'll close the contempt.
No, my lordship.
Inadvertently, the contempt was closed here. Also.
My apologies.
Yes, MSEB Prasad has just received copy of the application. She pays on the lot 2 weeks time to file affidavit. Yes.
9.
I want to call it supplementary. Yes, MSP check 3.
Your lordship, they have not filed affidavit yet. It's a contempt petition, lordship. It's a contempt petition, lordship. The order of the OA.
Where's the order?
The order is at page 30. 32 is the relevant portion from 32. It's the order of the
32.
OA. Yes, your lordship. From para 14.
This is whose order? The CAT.
Yes, your lordship. Then
From the High Court, madam.
after that they have
Yes, 53.
After they gave it in the writ petition, then
yes, that was dismissed, lordship. So as such, there is a violation of the court order.
Yes.
They could file in CAT, madam. There's a mechanism for that also.
They have contempt jurisdiction.
They have, madam.
Then
But your lordship, the High Court has dismissed the writ petition filed by the.
file affidavit. It's only a matter. Dr. Ambrosica please for the further 2 weeks time to file affidavit. File it or comply before that. File affidavit.
Oh, please, your lordship.
10.
I'm asking to file review now.
May it please the lordship. Lordship, we are praying for another 2 weeks' time to file our affidavit. On behalf of 1, 2, and 3.
Who's the period of 4
On
and 5?
behalf of 1, 2, and 3, Lordship. 4 and 5, nobody is at
An affidavit indicating service upon respondents 4 and 5 has since been filed. As such notice on all the respondents complete. Stop them. And like MST Young EAG today prays
2 weeks
for
time.
2 weeks further time to file affidavits. Place up to 2 weeks for affidavit for appearance or respondents.
4 and 5.
4 and 5.
Thank you.
11.
Your Lordship, that I may be allowed to take a step on the newly implemented parties, Lordship. 7, 8, and 9.
You already cleared, yes. Okay, Mr. S. Sheikh, response allowed. Your Mr. S. Please is allowed 3 days time to take steps on the unique respondents state of Assam. That is how many, let's see, who have been implemented, white order dated?
Order dated 12/8.
12/8/2026. So what about affidavits from your
You've already filed, Your Lordship.
You file also?
I'm praying for some more time, Lordship.
Yes, the affidavit of respondents 1 to 3 is already on board. Stop MSEB Prasa prays for a 2 weeks time to take steps or to file affidavit. Yes.
Aliya.
It was allowed for this after 2 weeks.
12.
Please, Lordship. This Lordship, this Butter, the subdivisional officer, they have filed an affidavit stating that the appointment of the private respondent number 7 had been cancelled, and now they have given the appointment to the petitioner hearing. Now only the remaining part is only they also stating that they are meeting only the approval of the director. My appointment should be just approved by the director. Matter can be resolved because the government who filed the affidavit is the subdivisional school education officer. Kindly see, my lord, the page number.
1 second. Just
Lordship.
What is your prayer? That they're not qualified?
No, they are not qualified means I have challenged this appointment
for 7.
I'm not paying for 7.
You've been removed from service.
But still, what is going on?
Yes, Your Lordship, inquiry is going on by the respondent number 2, Your Lordship.
Kindly
Inquiry
see
report
the
is-
second Lordship.
I could not file because Your Lordship, it was sent me without seal, so I have
No,
sent it for it.
but you've
But-
been appointed now.
Now I have, as per the affidavit, I am appointed. But the only
Whose
thing is just
affidavit?
there is affidavit filed by the subdivisional official,
Your
Lordship.
Lordship, he is not subdivision. No, Your Lordship, I am not
Not on record as
representing.
yet.
Hello, yes, Your
What are
Lordship.
you submitting? Is the subdivisional officer's record?
No, Your Lordship, he was made special officer for management of the managing committee because there was no managing committee. That's
And
why
you are
interim
paying for-
government.
For local council, Lordship, on behalf of respondent 5.
So, Your Lordship, it is not state inquiry has been already conducted, Your Lordship. I may be allowed to file, or Your Lordship may kindly have a look at
No,
that
you file it, yes.
because it is already ready. Just for
5, what's the role of 5? Yes.
Lordship.
I was the secretary of the special interim committee, my lord. What had happened was that the prayer that the learned petitioner is seeking in this writ petition, my lord, is setting aside of the order of the personal interview which was held on 30/4/2026.
Where's
the
that?
claim of the petitioner was that my lord, that's the prayer portion at page 18, my lord, page 18 of the writ petition.
No, where's the impugned order? Where's the
order which is
annexure?
impugned?
Yes, that
Kindly.
that is
May kindly come to
page.
page 53, my lord. Page 53. Page 53, my lord,
53.
is the typed copy, my lord. Page 52 is the original copy. Sujan Ali, that your lordship sees, my lord, that is, he has been arrayed as respondent number 7 in the writ petition, and the petitioner's prayer is that his selection should be set aside.
Right.
Now, thereafter, my lord, what had happened was that the interview had commenced and concluded, and the petitioner was rightfully the selected candidate.
Yes.
My lord, but there was some error on our part. Now, my lord, will kindly take up the affidavit that we have filed, which at page 66, my lord, we have revoked the appointment given to respondent number 7 and have given it to the petitioner, my lord. So the relief which has been sought for by the petitioner, my lord, in my humble submission, has already been taken care of, my lord. Page 66.
66 of the affidavit. The affidavit has
There
only
will be 66 running pages. Your Lordship, there is some irregularity committed by this respondent number 655, Your Lordship, because he
this is the affidavit by Spencer
is
Movement.
removed from.
Yes, my lord.
I don't understand his submissions at all. I'm sorry. I don't understand what you're submitting also. I'm
Your
very
Lordship,
sorry.
I am not.
Like, please I'm trying to understand the case. You think every case I have the fact at my fingertips?
Sorry, Your Lordship.
What page are you referring to?
My lord, the running page number 66, my lord. The running page 66 of the affidavit which has been filed by the respondent number 5, my lord.
On the this order dated 12 June 26.
Yes,
My lord. And that is the order, my lord,
Yes.
that gives the charge to the petitioner.
You've taken over charge.
I have taken over, but only thing is that only need to that my appointment should be just approved by the director. That is the only thing. Even they have stated in my affidavit.
Mr. M. Sharma, who's appearing for respondent 5 special, that is a special interim management committee,
A special interim managing
submitted
committee,
that
my lord.
the petitioner has since been appointed in place of the respondent number 7. The legal counsel referred to an order dated 12 June 2026 issued by the Secretary Staff. Mr. P.T. Sama, legal counsel for the petitioner, submits that this is correct and the relief period has been granted. However, what remains only for the approval will be granted by subdivision.
Yeah, it should be by the director.
To be?
By director.
By the director. By the director, yes. Are you appointed director?
Yes, sir.
MS Asbarachaji, what has he approved it or not?
Your Lordship, not yet, because inquiry as per recommendation of the inquiry committee, Your Lordship, there is a that they will take action against the respondent number 5, because after
Forget against respondent 5?
Respondent number 5, the special officer on
Why?
duty, because Your Lordship, he is the one who manipulated record, because petitioners Mr. P.T. Sangma is right, because he is the number 1.
Fine, so he's been appointed, so
Yes,
why can't
yes,
you approve his appointment then?
If-
The other thing is a subsidiary issue.
Yes.
Yes, Asbarachaji appearing for the state respondents.
1, 2, 3, Your Lordship.
1, 2, 3 submits that though the state have no issue with the appointment of respondent number 1 of the petitioner. However, issue remains with the conduct of 5 in the selection process. In his view, the matter, she prays that you bring the affidavit. What do you put in the affidavit about inquiry?
Yes.
That is a subject different.
Everything, all the document, because that person who has.
Fair 1 week and we'll close it next week. Yes.
Only my lord.
That'll be in record. Yes.
Lordship,
Yes.
may I?
Over. Yes, next.
Please, Your Lordship. Your Lordship, this is a fresh matter, has required 3 weeks time to file an affidavit. No.
Yes. I've paid for the 3 weeks of affidavit.
Obliged. Highly obliged.
14.
May it please, Your Lordship. My Lord, I'm praying for some more time, my Lord, to file the affidavit.
What's my pension?
Lordship, pensionary benefit and there are back wages also that has not been paid, Your Lordship. Lordship, if I may pray, Your Lordship. Petitioner is feeling some hardship, Your Lordship. He's under treatment. Lordship, since the amount, it's admitted, Your Lordship.
The amount is admitted amount.
Lordship, if you
Let's see.
back wages, Lordship, page 20, page 47, Your Lordship.
Page
47.
47.
Lordship. Page 47, and this is chart on page 48 till
page.
Chart is on page 48 till 54, Your Lordship, and on the bottom of page 54, Your Lordship.
Now, where's the admitted amount of back wages that is due?
Lordship, this is regarding to back wages also, Your Lordship, because there has been a criminal case pending against me, Your Lordship.
You have received instructions.
Lordship, I have received. My Lord,
What is the instructions there?
no, I've just received, my Lord. I'm bring like let it
When
come
did
after
you
1 week,
receive
my
it?
Lord. 1 week, my Lord.
When did you receive it?
On the 10th, my Lord.
10th.
Lordship.
Now is the 20th. You have not been able to look at them. Let's have a look at them.
Lordship,
He's suffering from what?
Lordship,
What's he suffering from?
Lordship, he's having a stroke, Your Lordship. Lordship, some amount may be directed to release, Your Lordship. Your Lordship may kindly grant me that. Lordship, this will be letter 30th June 2022, Your Lordship.
1 second. He has not said nothing about the admitted amount. Very twisted case. He didn't drop any DP against him.
No, Lordship.
Has been regularized in his post.
No, my yes, Lord. My post has been regularized in 2009.
Because initially he was appointed as ad hoc, my lord, for that period from 2006.
But then now he's suffering.
I was regularized on 2009, Your Lordship. Page 29 of the petition, Your Lordship.
Very unfortunate.
More in the meantime, I'll take instructions on that aspect.
No need to take instructions. You have enough instructions. Very difficult to navigate these instructions also. So like take down Mr. S. Kiriam submits that the matter has some urgency in view of the fact that the petitioner is already retired also.
Lordship.
Who has since retired. He has not been given his pension or his back wages.
No, Your Lordship.
Lordship,
back wages is also pending, Your Lordship.
Yes, it says to be paid back wages and some urgency as the as the petitioner is a stroke patient and is yet to receive his back wages or pension as computed. So the instructions received have been put by this court. It shows that there are many other factors in play. However, Learned Government Affairs having endeavored to file an affidavit within 10 days.
Lordship.
Yes.
In the meantime,
at least on the.
In the meantime,
if any amount can be given, otherwise hardship is just a chowkidar.
We try to expedite from the department.
Lordship, there's no.
15.
We don't want him to. But next time he comes and says that. Yes.
Obliged.
Highly obliged, Lordship.
Yes.
My lord, this is regarding payment of stamp.
Your Lordship, they filed a
miscellaneous application on which basis we wanted to settle because my financial position is not good. So we wanted to pay 60
I've done instructions
lakh.
on this.
Your Lordship, we have not received.
Why didn't you appear last time when the matter was here?
I was
this
not
case
well.
number 223/2026 in WC 339. This is a business application with a prayer to allow the petitioner to make a part down payment of rupees 60 lakhs towards stamp duty and registration out of rupees 1,95 lakhs 42,341. MSZ Nori is present behalf of the respondent of the parties to obtain instructions for next date. Yes, after 2 weeks, yes.
Lordship, my only submission is that the prayer in the miss case is also similar to the prayer in the.
Doesn't matter. Get instructions within 2 weeks.
Your Lordship.
Yes.
We'll take instructions, Your Lordship.
16.
May I submit, my lord, in this matter? May I submit, my lord? Your Lordship, I'm sorry, I'm not clear here. In page 48, my Lord, page 48, there was installment given, my Lord.
We'll hear you some other date next week. Yes, okay. Let's let next week. Yes. Yes. Next week.
Yes.
Not after 2 weeks. After next.
16.
You serve standing counsel of phone number 3.
Lordship.
No. Where's Mr. D?
3 is EB Pasa.
EB Pasa.
EB Pasa. Last date also she. Whether copy is given or not.
You given a copy to her?
Given. Your Lordship, I need some more time because I'm yet to receive instructions. Already.
Yes. MSSRC praise funds allowed. SPRC allowed GA for 1, 2, and 4 praise funds for the 2 weeks time to file affidavit. So submitted that counsel from respondent number C has been served. There's no appearance on behalf of the respondent. Yes, after 2 weeks. Yes. For affidavit.
17.
Your correspondent. Your Lordship, we are. This is Sandeep's case. We are supposed to file the affidavit. We need 3 to 4 weeks time because he is not here.
It's only a point of law.
Maybe Your Lordship, because I have no instruction. So after 3 weeks.
This is we haven't issued notices to the private respondent.
Yeah, not issued. Not issued.
With Dr. Mojika appearing for 6.
Yes.
Pro forma. Yes, Mr. Vicky Jindal said that he somewhat due to the absence of the arguing counsel. You're arguing also, he's arguing counsel.
He's arguing if he's not coming, I'll argue.
3 weeks time for affidavit. Yes, this is that after also.
Supplementary list hearing. Item number 2.
Item number.
See, we'll hear this matter till 12 o'clock.
12
break. We have the speaking of show more matter.
So more to
with regard to what happened yesterday.
Yes, my lord.
And Your Lordship.
My lords,
continue after that.
My lords, one very my lord's query. My lords have given a very significant query yesterday, my lord, because now the only contention of the respondents is that on the basis of the roster, they have scaled down, or eligibility criterion has been changed to favor SC and OBC candidate, my lord.
Your Lordship, he is making a wrong statement. No, I mean, Your Lordship, it is absolutely beyond the pleading what he is speaking.
Yes, let him.
Yeah, that's exactly.
Show where I have stated.
No, that's exactly where I'm saying. Well, I've shown the paragraphs where they have stated, my lord. They're saying that it's a reservation roster, my lord, and my lords. Correctly, my lords have put a very significant questions to me whether you challenged the roster system in your pleadings, my lord. Of course, my lord, in my humble submission, I would be very candidly clear, my lord, that I have not challenged, my lord. Why I have not challenged? Because my initial challenge was something else, and they brought in their defense the roster. They justified the roster. How? Why did they?
Have you assailed that point?
My lord. So therefore, my lord, now, my lord, then what happens significant for me is, my lord, to challenge the roster system in which they have appointed, my lord, because it becomes a good ground, or it's a new ground for me to challenge, my lord. Of course, because then I cannot be done away. Scaling down from 15 years to 5 years is not minor, my lord. It's huge. A decade, my lord. And where the two categories, my lord, of course, we are reserved. What categories are reserved under the Constitution? 351, Article 351 for the scheduled caste, Article 342 for the scheduled tribes, my lord. To uplift these two, my lord. Now, for one set, you said 15 years eligibility criterion. For the other one, you said 5 years. So it's a huge gap, my lord. And now the point is, my lord, since they have brought on the roster, my lord, may I pray, my lord, let the entire how, in what manner, on what functional way they have calculated the roster points. Then we'll have to go from the records, my lord, which we are not. If my lord directs them, it will be clear, my lord. And if they have done in accordance with law, then I have no case at all. But if not, then that gives me it gives me the handle to challenge that.
Have you addressed this point in your rejoinder affidavit?
I have not rejoined. Okay, candidly, my lord. Therefore, what I am praying.
See, the thing is that
yes,
you win.
Yes.
Now, this point is the reason you say, because
my lords,
the whole matter started. There was a unreserved seat, correct?
Yes.
Then the scheduled tribe candidate got appointed, correct?
Right, my lord.
Now he was appointed. You were number 3 in the list, correct?
Yes.
So now you see, now the course of the hearing, it's emerged that is totally gone. That issue, what should have gone unreserved, now the ST has been encroached upon, and the subsequent advertisement is only OBC and for SC, correct?
Yes.
So that is where we stopped yesterday.
Right.
So that's
my
the
lord.
thing. And now you say that because this point is very vital, and it was not challenged by you. Okay, fine. It was addressed by your rejoinder also. Now you want to ask for the records. How will that be? How will that be sustainable?
My lord may, because my lord, that's one point, my lord, that's criticized. But the other point also remains, my lord, because this, if you look at the advertisement that I have annexed in my writ petition of 2024, that's one advertisement just before the advertisement that I have applied immediately. There also 15 years, and in that also, my lord, a special seat was reserved for the scheduled caste. It was reserved for scheduled caste, and the criterion also was eligibility 15 years. Then the next advertisement comes where we have applied and where we said that as per your recruitment rules, we were empaneled. Then within 6 months, another advertisement comes, my lord. The seats are there. Other advertisement comes. First, they stick to 15 years. They admit that 2 tribal candidates have applied, but none of the OBC and SC candidates could apply. Why? Because they do not have the eligibility criterion. That's why we scaled down to 5 years, my lord.
To fill the roster.
To fill the roster. Now, therefore, my lord, this roster becomes very important, my lord. Because therefore, my lord, I admit, my lord, I admit that I have not taken the plea even in my rejoinder inadvertently, my lord. So therefore, what I am seeking, my lord, kindly allow me to file an additional affidavit if it's permissible, my lord, so where I can specifically, categorically challenge the roster points also, my lord, because the functional roster points, they are also not saying anything. They are only simply sitters saying that we are following the roster system. How can that be? Because 2024 you have given a seat to SC, 2025 the March advertisement you have given an unreserved seat, and now within 6 months you are giving another advertisement for the same post. So there is no rationality at all, my lord. They have not even demonstrated anything else.
Interesting point.
Your lordship, I'll make my submission.
You will have your chance to
yes, my lord.
Yes.
To refute it.
First of all, whatever he has submitted is totally out of the record and the pleading.
Of course, he has said also that
he is placing the thing in a very different manner. Only for 10-15 minutes are left. I will give reply only to the points which he has raised. The first point, your lordship, he has raised relating to the recruitment rules. Your lordship, he has given a copy of the recruitment rules 1983.
Yes.
And he has referred to subpara 4.
Yes.
The selection committee will arrange the names of the scheduled candidate in order of merit, and appointing authority will make appointment in that order unless for any special reason to be recorded it is found necessary to vary that order in any particular case. Panel of selected candidate. Your lordship,
where reading from 83? No, that's the second one. That's the revised recruitment rules.
Pardon?
You're reading revised or the order?
Yeah, these orders are already revised. That's what and moreover, your lordship will find clause 7.1. When a post is to be filled up by direct recruitment, including recruitment from the sources indicated in item number A to D under Rule 4 above, The governing principle shall be to secure the services of the candidate most suitable to the post. To achieve this objective, the method of recruitment shall be to invite application by open advertisement. Your Lordship will find clause 7.1 applies only to the direct recruitment. It doesn't apply to the, and here it is not the case of the direct recruitment. So my point is this, that subclause Roman 4 of clause 7 of the earlier recruitment rules 1983 applies only to the direct recruitment. Here,
we said direct recruitment from outside. Yes.
Yes.
But the caption is direct recruitment from outside.
Yes.
7.4 says like a committee arrange the names like an.
Yes.
Okay.
So
okay.
This applies to the, and another thing, coming to the NEPCO revised rules, which he has annexed along with the affidavit in opposition.
Rejoinder affidavit.
No, in the rejoinder affidavit at page 6.
Yes.
Page 6.
Yes, excuse me. Yes.
He refers to, here your Lordship, he refers to rule 19.2 and 19.3. Operation of panel of selected candidate. Now he refers that this panel is to be kept open for a period of
1 year.
12 months. 12 months.
Yes.
Here again your Lordship will find that these rules, your Lordship will come to page 6. These rules were notified by Office Order number 2 dated 24/10/2025, and this rule came into force with effect from the date of approval by the board, that is 15/9/2025. Now again your Lordship will find that these rules have got two parts. One part deals with the direct recruitment and second part deals with the
promotion.
Executive trainee scheme. Here the executive trainee scheme.
Okay.
Scheme. These posting questions are not in the direct recruitment, but they are under a particular scheme that is called executive.
It's outside the scope of these rules then.
Outside the scope of the direct recruitment. No, there are special rules for that.
Where are those rules?
Here in the same.
In the revised rules only.
Yes, in the revised rule
which
itself.
Part is it?
Your Lordship will come to.
Okay, Mr. Human, how soon did you file additional affidavit?
My lord, I can file it tomorrow itself, my lord.
Today itself?
Tomorrow.
Very good. We'll rise now. How many matters? We'll resume.
Your Lordship, after hearing me, if your Lordship allow him to file, because I have not been able to give a counter to his submissions, and if your Lordship, after hearing me, finds it necessary,
no,
your Lordship
it's just for the information of the court also. We want to see what kind of roster points you maintain in NIPCO. It's just for my lordship. Maybe it will not be.
No, here your Lordship.
It might not be to assistance also.
Lordship, he is totally
on a wrong wicket.
No, misinformed. Here the reservation in questions is not the general reservation which is notified by the Government of India. That is.
No, that's why you want to. How do you maintain the roster points?
No, now that is outside the scope of this writ petition.
Exactly, but let's see.
And here, your Lordship, is the question of the 10% reservation, and for which there are special rules and the special regulations, and this is not falling under the general reservation.
Okay, you let him file it by today.
Today.
And the acceptance of that will be subject to the outcome, subject to my submission. By tomorrow, and let it come on Monday.
Monday.
So Yuban submits that praise email out to bring on board the affidavit with regard to the
roster, my lord.
Roster maintained by the NIPCO. So, objections have been raised by Land Senate Council to this prayer. As it is submitted that it is outside the scope of the pleading petition,
yes,
and also the issues involved therein.
Yes.
So, that be as it may, the
admissibility of this.
The absolute affidavit will be taken into account after hearing the Senate Council. Yes. When?
24th, sir.
My lord, let's come with first September, my lord. We will not adjourn because next week I'll have problem, my lord. Tomorrow I'm filing my affidavit. First.
We are here only.
My lords.
Yes.
First September, there you
Yes, 5 hearings.
Because he is install my selection process. Your lordship.
No, my lord, there's.
No, but there's something there. Yeah.
Yes, my lord.
Why should he come? The thing is that the reduction in the criteria also.
Criteria,
that's the only thing.
No,
15 years for in service, then
lordship,
suddenly you reduce it to 5 years.
No,
so you can bring more people. Are you applying different standards for
no.
like 2 sets of people? Yes.
Much obliged.
Yes.
1st September.
1st September.
First, any date you want. 1st September, 30th September.
Much obliged.
Yes.
22.
Your Lordship, the District Council is supposed to file the.
Yes, Your Lordship, I'll file it positively with this also.
Isn't the hearing or file affidavit?
No, just to bring on record the orders of the council, Your Lordship. Because those were not brought on record by way of an affidavit before.
Sir, in my my lord, in my humble submissions, my lord, there are just 2 points, my lord.
Elmer your junior. Elmer your junior colleague. 6 and 7.
Your Lordship, I'm appearing for respondent number 5.
6 and 7, I'm appearing.
Why not filing it?
No, I have already filed.
Okay.
I have already filed.
But additional affidavit on behalf of 6 and 7 has since been filed. So the same on board. Stop Mr. MS Keith Nongri on behalf of respondents 1 to 4 submits that. What is your submission?
Your Lordship, to bring on record the orders
Yes,
of
submits that the affidavit to place some records and materials will be filed within
1 week. Your Lordship.
within 1 week. Yes. Yes, thereafter. You give copies.
Hello.
Also.
Hello.
Huh? We take up
27.
You take up this matter today?
This matter can be remanded back, in fact.
No, I mean then we'll take it because 12 o'clock we just bring for the revision bench.
You can take it after.
27.
Where's Mr. P.T. Sangma? Yes.
But I think my friend won't have any objection if the matter is remanded back to the.
Yeah, objection.
I don't know, to the deputy CM, because the issue.
Provided that only those order passed by the CEM, the deputy CEM, he has passed 2 orders. Should not be, that order should not be set aside, because that order was passed to maintain the status quo.
Yes.
Because that particular land was never touched since from time immemorial. Now the opposite party, the petitioner here, they are trying to cultivate the land, because that particular land was without untouched, means like no cultivation was going on, because we are allowing other part of the area to do whatever cultivation on that. Only the particular land, because in the order of the CEM, in the miscase in the 2 order, has passed only to maintain the status quo. That means like no need to do any kind of activities in that particular jungle. That is it. So if that order is not set aside, we have no problem in reminding the matter, because that as it is, the case is pending before the EM. Because there is a provision.
You can't stop it. They haven't finished the machine.
There is a provision for appeal also, actually. They, instead of coming and filing an appeal before the CEM, they have come against the order of the EM. Because there are 2 orders, because they have challenged. The one order is order dated 19/10/2023. That was passed in the main case of GHDC Revenue AC of 2018. That order, and another order was passed on 7/3/2025 in the miscase number GHDC Revenue 92 MC of 2024. Well, they have only just passing that to maintain the status quo, means like the petitioner should not be the cultivate that is the only part. So otherwise also if they are aggrieved, they have there is a remedy for them. They can file an appeal before the CEM and EM.
What happened here? This is in respect of recognition of an aking. Now, your Lordship will come to page 87. Now, as far back as on this was judgment passed in 1996 by the division bench of this court. Page 87, my lord, only the last part, para 8. So it is therefore it is the
party this matter, I hope.
No, my lord, I have not done that.
Yes, no. Yes, I've seen that. Yes.
Para 8, my lord, it is the prerogative of the authority to recognize the aking. The authority found that the land was in possession of the respondents, that was us, from a long point of time. This finding of fact cannot be disturbed in this writ application, and the next question regarding recognition of the aking is also under the jurisdiction of the authority, and that was done by the authority. Accordingly, the contention put forward by the Learned Counsel for the petitioner has no force, and the same is rejected. So the matter was set at rest by this judgment. What happened, Manoj? Subsequently, that is
now you're against the
yes. Now it is what the deputy.
Now
he has reopened.
Kings, which one? Huh? Yours the name of
Sakalgre.
Sakalgre.
Yes.
Now the things are that being factually having found lands in possession as para 7.
Yes.
And as such a pre-claim was duly considered by the authority. So at that time it's considered, and then they said, okay, Sakalgre exists.
Yes. Okay. So it was set at rest. Now in 2023, they again filed an application before the deputy page.
What's the order? I mean,
98.
98.
98 is the order. By 98, by order dated 19/10/2023.
Now just let the court understand. Yes. Now, Baldengre, you are the Nokma.
Lordship.
And Mr. Dingdo is for Sakalgre.
Yes.
Now, when the time came for constitution of Nokmaship, you objected.
Yes.
What is the case?
Because we are contention in the lower court is because this particular
you objected to the registration of the Nokma of Sakalgre.
Yes.
Before it is the council.
Yes. On the ground that Akang does not exist. That Akang
but
is
then
the part
order
of the
division bench that is already been considered and they've been possession of that land for a long period of time.
Yeah, Lordship, because that order was never been implemented.
Oh, that's very sad then. Out of court.
I mean, like because
if I can. So that's why Mullah, I said let it go back.
Now they are not again
to the deputy C.
So he says that now this order says proceed the case afresh.
Afresh.
It was filed by them, right?
Yes.
Jemson, okay.
Jamson, we became the respondents. Now we have filed a WS also, my lord, before the Deputy CM at page.
Okay, this is one order.
At page 100.
1910-2023.
That is at page 1.
Now, unfortunately, my lord, this order was never challenged. Mr. P.T. Samma has correctly pointed out that an appeal against this order should have gone to the CM.
CM, yes.
To that extent, I also I would not. So this was never challenged. But then we filed our WS, my lord, which is at the next page, page 100.
Yes.
Now, if your lordship will come to page 107, we have raised the issue of res judicata, that you cannot reopen this matter. Yeah. So my submission at this stage is that let the matter go back to the EM and let him decide the issue of maintainability.
Yes, Mr. P.
That is all.
My lord, may kindly see the order which is under challenge before this honorable court is 1910-2023.
Two orders.
And then, my lord, 7-3-2025.
Which page is that?
One is page 98, what my lord senior has pointed out.
And the other is
and the other is on 169, my lord.
169.
Now, if my lord may kindly see 169, 7-3-2025.
What does it say?
It says to maintain status quo, my lord. Yes. What I can understand from the last paragraph, my lord.
This is before the
EM revenue, my lord, who was the deputy CEM, my lord, at that point of time. Now, my lord, may kindly come to page 171, my lord.
Yes.
This is the last paragraph, my lord. Both parties shall not disturb the peace and tranquility of the area in dispute and shall not engage in any activity that may lead to law and order issue and communal disharmony. Any party found violating this direction shall be liable for appropriate legal consequences. Any violation of this order shall be viewed seriously and may result in appropriate legal consequences. I don't find any wrong in this, my lord. When there is a claim and counterclaim, my lord is aware.
Like to make
anyway, whether
just calm down the situation, my lord.
We'll dispose it of.
Yes.
Okay. Yes.
Only thing is this, my lord. This order may not be interfered with, my lord. This order.
The status quo order.
Yes. Status quo.
Yes. But then the EM should take the maintainability issue into.
Yes. You didn't go for the CM. Why against the order?
That I cannot say because of this. In fact, the brief came to me only just a few days ago.
That was our preliminary objection over the maintainability.
Yes.
Yes.
Ill advised.
Heard legal counsels for the party stopped. The petitioner had come before the court, assailing an order dated 1910-2023, passed in GHEDC capital REV of that /53 AC of 2018, and order dated 07/03/2025, passed in Miss Case number 92/2024 in GHDC Revenue 53 AC 2018 by the District Council respondent stopped. The issue in question concerns the dispute has been raised by the respondent to the registration of the petitioner as the Nokma of Sakalgiri Aking. So this matter, it appears, was taken up by the where's that page? Taken up by the executive
now it is the EM, my lord, not deputy CM.
It was taken by the office of the
EM revenue,
chief executive member in charge land and revenue, who by order dated 1910-2023 was pleased to direct for conduct of spot inquiry and to proceed with the case fresh. Stop. It is also noted that in this impugned order, it is observed by the member in charge land revenue that some orders had been passed in favor of Baladingre bracket respondent, and some other had been passed in favor of Sakalgare, which is the petitioner. Stop. Stop. The second order which has been impugned is an order dated, is the order dated 07/2025, which is whereby the Deputy Chief Executive Member in charge, so in this case, and in the miscase aforementioned, had directed for maintenance of status quo of the area in dispute and not to engage in any activity that may lead to disruption or law and order problem. Stop. Next paragraph. Mr. T.V. Dingdo, Allen Senior Counsel, on behalf of the petitioner, has submitted that the issue in question, in fact, had been settled before this court itself by an order dated 6/9/1996, passing Civil Rule number 3866 of 1991, wherein this court, the then jurisdictional court, that is Guwahati High Court, had come to a finding on the objections filed by the respondent, taking into account especially taking into account the factum res judicata and whether it apply to instant case. Top next paragraph. Mr. S.D. appearing for the official respondents numbers
1, 2, and 3.
1, 2, and 3 submitted that the initial objection of these respondents was to the fact that the petitioner directly approached this court without first exhausting available statutory remedy as provided under
Section 8
under Section 8 of the regulation.
8(2).
He submits that as the General Counsel, as Senior Counsel petitioner has now clarified the position, he is not averse to acceding to the prayer for remand of the matter back to the executive member in charge.
Without disturbing the order.
Yes. Next paragraph. PT Sangma. Yes, though initially has raised some objections, but in view of the submissions made by the parties, especially the official respondents and the petition and the legal counsel petitioner submits that the matter can be remanded, but for
only that order did is
for a fresh
yes.
Fresh consideration. However, with regard to the second impugn order,
yes,
the Learned Counsel prays that the same may be maintained so that there may be no disturbance in the areas in dispute. On hearing the counsel for the parties, this court on hearing counsel and this court on the concurrence that's been arrived at, accordingly demands that is what's the name of the case? This is the case number. Case JHDC REV/53 AC 2018. Yes. Back to the court of the executive member in charge review for fresh consideration, and consequently the impugned order dated 19/10/2023 shall stand set aside. However, with regard to second impugned order, that is 07/2025, passed in the miscase, the same is maintained and shall be in operation till further orders are passed by the trial court, by the court of the trial court. It is further made clear that as a preliminary issue has been raised with regard to justice judicata, keeping in mind the earlier litigation in the matter, the learned court of the EM in charge definitely shall take this point into consideration before addressing other issues.
Much obliged.
Accordingly, as ordered above matters, then dispose of it.
30.
Okay.
May I please, Your Lordship?
Yes, Mr. Lasongya.
Your Lordship, this matter pertains to compassionate appointment, Your Lordship.
Compassionate appointment?
Yes, Lordship. The petitioner's late father was working in the PWD department.
Died in harness when?
2006, Your Lordship. He was a regularized work charge employee, Your Lordship, in the department. If you can take Your Lordship to page 9, Annexure 1.
Work charge employee will be entitled to compassionate ground.
Lordship.
Yes. Page 9.
Page 9, Annexure 1 is the death certificate, Your Lordship.
Yes, he died. Okay.
28th March 2006, Your Lordship. And the petitioner had approached the department, Your Lordship, in the same year, and he was appointed, Your Lordship.
Was appointed? He approached how?
He approached the department, Your Lordship, for compassionate appointment.
No, by a proper application?
No, Your Lordship. The petitioner being uneducated and being an illiterate, he was not guided by the officers of the department, Your Lordship, for compassionate appointment or the need for or the requirement for filling up of the standard application, Lordship. And instead
no, but see, whether work charge employee will entitled, because work charge employee, when his service terminates, everything dies with him.
Yes, Lordship, but he was a temporary place, Your Lordship.
No, but he was given a job on 1606.
1606, Lordship, page 11, Annexure 2. Yeah. And his services were extended on several occasions, Your Lordship.
Working now?
No, Your Lordship. His services was terminated in 2015.
Okay.
And then, Your Lordship, based on the letter issued by the department, Your Lordship, Annexure 5, page 62, his services was terminated, Your Lordship.
He continued for how long? From
9 years.
Okay. Roller handyman.
Yes, Lordship.
But his was a period of 2 months only. It's extended every 2 months.
Yes, Lordship. Not necessarily 2 months, Your Lordship.
Okay, Annexure 4.
Annexure 4, Your Lordship.
317 to 28.
These are series of his extension orders,
2
Your Lordship.
months. 2 months.
2 months, Your Lordship. And then in Annexure 5, Your Lordship, he was terminated based on this communication letter, Your Lordship.
Page?
For 62, Your Lordship. Annexure 5. For irregular employment.
Read it.
Yes, Your Lordship. And in the year 2016, Your Lordship.
Read it. What does it Annexure say? The font are very small.
The type copy is at page 63, Your Lordship.
Oh, okay. That is what is.
Yes, Lordship. But if I may take Your Lordship to page 80, Lordship, Annexure 7. The department had revived the petitioner's case, Your Lordship, for appointment on compassionate grounds.
Compassionate ground will not arise because you see, when you appointed work charge now, or you regularize in that post, everything dies with you anyway. Yes. Where? Page?
Page 80, Lordship.
80.
And it was only in the year 2018 that he had submitted his standard application, Lordship. At page 84, Annexure 9.
What's he doing now?
He's unemployed, Lordship. Subsequently, the petitioner had sent a representation at page 90, Annexure 11, explaining his grounds for the delay.
See, how can you reconcile? See, what do you see in the affidavit?
We have stated, Your Lordship, that the father of the petitioner, was a work-charged roller driver, and he was in 1993 when it was clearly mentioned in the regular that once a person who is regularized or confirmed in that post dies or superannuates, that post ceases to exist.
That's what. That's the whole.
Now, there is
concept
no
of
way
that.
that this petitioner
No, but then why is
could
this?
have been
It's like a
appointed.
sort of sovereign action on the part of the.
He was also appointed as a work-charged employee, Your Lordship.
Yes.
This petitioner was also employed as a work-charged
The
employee.
petitioner was made to believe that he was appointed to elevate his family hardships, Your Lordship.
No, fine. If we understand, see what happens in these cases. Suppose a person dies, then the engineer, the person used to serve, certain engineer, you can at that time it's just by rule of thumb. He'll just give you a temporary appointment. Okay, you start just
But he was being
just to help.
extended
But then
every
the thing
2
is
months.
that the thing is that
You ought to have applied for some other job or ought to have gone.
No, not that.
And then
It's not
now,
that, I mean-
after the compassionate scheme, appointment and compassionate scheme has already been abolished since 2010, Your Lordship. Now he comes in 2018 applying.
what to do, Mr. Larson? You explain to your client.
So there is no way we can give him an appointment now, Your Lordship, because it is against the government
In compassionate
policy.
employments, Lordship, work charge and regular employment
You
is
understand?
irrelevant,
That's
Your Lordship.
compassionate grounds different. Work charge is totally different.
And here they have come before Your Lordship for appointment and compassionate ground. And there is no post vacant, Your Lordship. And so much time has lapsed, Your Lordship. There's been a great delay.
When do you come with the petition?
25.
After 10 years?
Yes, Your Lordship.
Your Lordship.
You take instructions. You tell your client that the court and inclined to take up a matter because
Lordship, if the petitioner's employment was irregular, why did they appoint him in the first place, Your Lordship?
because this
They were just
officers
trying
who are working, it's just out of compassion they give you that in the temporary job. You tell your client that 10 years also we can't maintain, notwithstanding anything else.
Lordship. Lordship, by Lordship.
Madam.
Yes.
Why did he come to 10 years then?
Lordship, he made the representation, and based on the representation, he was awaiting instructions.
For 10 years.
Yes, Lordship.
Yes.
31.
Yes. What is this?
May please, Your Lordship. Your Lordship, this is a writ petition, Your Lordship, for considering the regularization of the petitioner. Your Lordship, a brief of the case, Your Lordship. The petitioner was allowed to officiate as sweeper against the leave vacancy of her ill father, Your Lordship.
Of her?
Ill father, Your Lordship. Your Lordship, the annex page 10, annexure 1, Your Lordship. The type copy is at page 11, Your Lordship. Your Lordship, she was allowed to officiate as sweeper against the leave vacancy of her father, Your Lordship. What has happened, Your Lordship, on the death of her father, she was appointed.
Is it he or she?
She.
Or she, yes, okay.
On the death of her father, she was appointed to officiate as sweeper, Your Lordship. That is annexure 3, Your Lordship. Type copy is at page 18. And
Annexure 3.
Annexure 3, type copy.
09, yes.
Annexure 3, page 18, Your Lordship. Page 18 is the type copy.
Yes.
She was allowed to officiate as sweeper, Your Lordship, in the same capacity of her father. Thereafter, Your Lordship, she was regularized, Your Lordship, by the that is at page 20, Your Lordship.
Yes. By DMH only.
Yes, Your Lordship.
Yes.
She was regularized as sweeper on compassionate grounds, Your Lordship, and posted at Markasa, PHC, Your Lordship, in the same capacity as her father, Your Lordship. And Your Lordship, if we come to the affidavit of the state, Your Lordship.
Been regularized by incompetent
Yes,
authority.
yes, Your Lordship.
Yes. How long you work? You're still working now also?
Yes, Your Lordship.
You've been working since?
Since 2007, Your Lordship.
Then why you're not coming under that cabinet memo?
No, Your Lordship.
Wow.
Your Lordship, to clarify my post, Your Lordship, she had filed an RTI application, Your Lordship. That is Annexure 5, Your Lordship.
Now, what is page 23?
23 is the reply, Your Lordship. The reply to the RTI application, Your Lordship.
Oh, yeah, after 3112.
Yes, Your Lordship.
So you fell outside the what deadline or whatever the.
But Your Lordship, if we come to the second last paragraph, Your Lordship, her name has been included in the list submitted to the government for regularization. And Your Lordship, if we come to the affidavit of the state, Your Lordship.
Page 24 was showing. Now
Yes,
showing your date of appointment is
2000.
3009.
Yes, yes.
So you're outside the 2007 cutoff date.
Your Lordship, if we come to the affidavit of the state, Your Lordship, Annexure 1, page 10, Your Lordship. Your Lordship, if we come to para 11, page 11, para 10, Your Lordship.
Page 11.
Page 11, para 10, Your Lordship.
Yes.
May I read, Your Lordship? Application.
No, but the commercial why? What did he say in the affidavit?
Lordship, if I may, our stand is very simple. The fact is that there was an attempt of purported regularization without government approval, specifically the approval of the Department of Personnel. So this is one of those cases where a government office had sought to regularize, but without the approval of the state.
Done by competent authority. That's anything done by the DMHO himself. It should come from DHS.
Yes, Your Lordship. It should follow the para 10,
So
Your
where are you
Lordship.
still working now also?
Yes, Your Lordship. Your Lordship, if I may, Your Lordship, para
in
10.
a temporary basis. Are you being paid regular pay scale?
No, Your Lordship.
Yes, no.
It's less.
You paid what consolidated pay?
Yes, Lordship.
What's your pay?
The scale of paid rupees, Your Lordship, come to para. I don't know exactly how much, Your Lordship, but as per page 18, Your Lordship, as per the
Of your
order
petition.
of my petition, Your Lordship.
Okay, let's see.
As sweeper in the
Page
scale,
18.
yes, as sweeper in the scale of paid rupees.
240.
Okay, you paid, you paid you're being, that was in 09.
This is 09, Lordship. There are things that have moved on.
Regularizes. What's happened to there's supposed to be some other exercise with regard to regularizing these who are fall outside a cutoff date?
Lordship, that is subject of the cabinet memo. Is that what your Lordship is speaking about?
Memo 2022, but
Right.
the cutoff is 2007. Now they fall outside the
outside
cutoff,
the
so you'll have to
2007.
include it there. That's why the page 23 is there, where he asks for the date. So you still continue to work now also?
Yes.
The same place
Yes, Your Lordship.
since 2009.
Since 2007, Your Lordship.
2007, they were appointed on compassion basis. And Lordship, their name is there in the list for regularization. It's not
Yes,
that
yes.
it has been shut.
No, it's 2009, yeah. See, sanction order not traceable, permanent, retention and close. What to do, MSM, in your case?
Your Lordship, I pray that direction may be passed to the authorities, Your Lordship.
To do what?
Your Lordship, if we come to para 10, Your Lordship,
A
it is
mandamus can issue for regularization.
it is the default of the department, Your Lordship, to delay her
No,
name.
the only thing is that they can take a notional thing that you've been working since 29/12/2006, that's all. But the fact remains that your effective order, right or wrong, is from where's the order?
2009 was the
2009. Where's that? This is the order. This is the order at page 18. After he expired. Because the earlier on was your officiating appointment. After your father expired, then the post was vacant. So then you're allowed to officiate as against the said post. That's why you're enjoying the regular scale of pay. Correct? Against leave vacancy, yes.
And as your lordship will see, her name is on the list for regularization, for consideration.
Notionally, take down his heard MSEDC and the counsel for the petitioner, and Mr. Atyar is there for the state respondents. The prayer petitioner, we have the instant petition is for realization of our services as sweeper in Markasa PHC. Stop. On the ground that she has been serving in the said post continuously since being appointed initially against the vacancy and later allowed to officiate against a post against the same. Stop. Next paragraph. MSEDC General Counsel Petitioner has submitted that the petitioner initially, by office order dated 29/12/2006, was appointed for 90 days, or for
as per rule,
a vacancy created by a father who had availed of 90 days earned leave. Thereafter, she submits on her father's expiry, the petitioner, by subsequent order dated 4/3/09, was allowed to officiate against a said post.
Lordship may observe that it was pending government approval. I would stress that.
No, that's different. Right. Yes, that is he's allowed to officiate against the post 4/3/09. He submits that on 24/11/09, the district medical health officer then regularized the services of the petitioner on compassionate ground in the same post itself. However, he submits, in spite of being regularized by the DMHO, the same did not receive the approval. He's written that. We don't say that.
Page 22, Your Lordship.
Inside of it, her services.
That's not
services as reflected in an communication date 8/10/2025 continues on an ad hoc basis. Stop. Mr. Atyar is the counsel for the GA has submitted that the petitioner, though allowed to officiate against the said post, was not regularized by competent authority, and such can claim no right on the basis of the office order dated 24/11/09. He further submits that as the petitioner fell outside the cutoff date of 31/12/2007, wherein a cabinet decision has been taken to regularize the service ad hoc employees appointed prior to this date, is also not entitled to the benefit of regularization. Therefore, submits that no grounds been made out for any interference, and the petition is liable to be dismissed. Yes, that's correct. That's it.
Please, Lordship.
On hearing the counsel of the parties, on perusing the materials as available, as submitted by the counsel for the petitioner, It is noted that the petitioner had been allowed to officiate against the same post from 29/12/06 and thereafter on the expiry of the incumbent, as the father, was allowed to officiate again on a regular scale by order dated 4/3/09 issued by District Medical and Health Officer. This court also notes that on 24/11/09 the DMHO had regularized the services of petitioner. But however, as submitted by the Lankan GA, the same is not yet, and it's on the ground that the realization had been accorded by an incompetent authority. As it is submitted that the petitioner also after that further as can be seen from the facts illustrated above, as a date and year of ad hoc appointment of the petitioner as per official records is taken to be from 4/3/2009, which is beyond the purview of the regularization exercise by the cabinet, which had fixed the cut-off date of 31/12/2007. Thomas? What? Illustrated above. Yes. From the official courts. Yes. Conducted by cabinet fixing 31/12/2007 the cut-off date. Stop. Though noting these facts, but in view of the situation of petitioner, where though not an ad hoc service has been serving in the said post since
2007.
2007. This is really compassionate since 29/2006. Perhaps the respondents may consider the prayer made by the petitioner for realization by notionally taking the initial date of official appointment into consideration. Accordingly, the matter is disposed of as ordered above. Matter also disposed of. The respondents are to consider the prayer within 6 months from the date of order.
Wait for.
If they can give a poor thing, he's been working 2006 ago.
I'll seek instructions.
33?
No.
With directions on window.
Yes. Yes.
May I please, Your Lordship? Joint request for attorney, Lordship. After week, Lordship.
Why?
Due to personal difficulties, Lordship.
Because you're coughing?
No, Lordship.
Oh. Okay. After 2 weeks on a prayer of the parties.
Highly obliged, Lordship.
So, further.